Now, these are obviously improper redactions.
And let me stop for a minute.
I'm talking.
No.
I'm
if they're
talking.
not privileged,
Quiet.
Don't yell at me. If they're not
Mr. Chairman, would you stop the
though
clock?
you
This is
use-
on your time. It's not on Mr. Goldman.
they're not
Even though
privileged,
you used your
if we review
improper
them and they're not-
redactions
you'll like my answer.
to
If we
continue
review
to
them and they're
protect.
not
What happened next was chaotic from the start. There were clear issues with how the redactions had been handled, and the tension in the room rose quickly. One voice tried to clarify, saying, "Let me finish. I'm speaking, and this isn't privileged." Another interruption followed, with someone asking the chair to pause the clock. The chair responded that the time belonged to the speaker and pushed back against complaints about improper redactions. The back and forth only added to the disorder. Then Congressman Dan Goldman took the floor, and he came prepared. During a heated hearing with Attorney General Pam Bondi, he brought printed documents tied to the Jeffrey Epstein case. Records, he argued, were being kept from the public. Holding the papers up for everyone to see, he directly questioned why certain materials remained undisclosed, and whether powerful individuals were being shielded while survivors were left exposed. Instead of giving a clear explanation, Bondi appeared visibly frustrated. As the questioning intensified, her tone reportedly became sharper. At one point, she shifted focus entirely, holding up mugshots of immigrants and attempting to redirect the discussion. Critics argued that this move did nothing to address the documents Goldman was referencing, and only distracted from the original question. The exchange quickly turned into a tense confrontation, with interruptions, raised voices, and procedural disputes dominating the moment. What began as a direct inquiry about withheld files escalated into a broader clash over transparency and accountability. When the floor was formally recognized, Goldman thanked the chairman and continued pressing his line of questioning, insisting on answers regarding the handling of the Epstein-related records and the decisions surrounding their release.
Thank you, Mr. Chairman. Ms. Bondi, I went over to the department yesterday for a couple of hours to review some of the unredacted materials. And I am looking forward to your detailed explanation for why you have withheld almost half of the documents, which is required by the bill. Now, obviously, there are 3 million documents, so I didn't get through much. But one thing I didn't see was the client list that you said you had on your desk a year ago. I did, however, find a couple of important documents. An 86-page prosecution memo from the Southern District of New York, and a draft indictment from Florida against Jeffrey Epstein's co-conspirators. For reasons that I cannot understand nor are permitted by the bill, they were still redacted, even for members of Congress. So, Ms. Bondi, will you commit right here to immediately providing those two documents in unredacted form to members of Congress? Not a complicated question.
well, I guess it is for you because you have a law degree and those are privileged.
Okay, they're not privileged, but we will discuss that later. I also found an email that I have right here from Jeffrey Epstein to Ghislaine Maxwell that was unredacted, and it included notes of statements that Donald Trump made about his prior relationship with Jeffrey Epstein. Now, there is no reason for this to be hidden from the American people. There is no privilege, there is no attorney-client privilege, and I see you're checking with your staff, and I can assure you, staff, this is not under attorney-client privilege because it was sent from Jeffrey Epstein to Ghislaine Maxwell. Will you commit to publicly providing the unredacted version of this so that the American people can understand the extent of Donald Trump's lies about his relationship with Jeffrey Epstein?
You're about as good of a lawyer today as you were when you tried to impeach President Trump in 2016. Have you apologized for that in 2019?
So will you unredact this? Will you unredact this?
You were lead counsel on that. Privileged.
I'm asking you, will you unredact this?
Privileged.
Privileged, of course. I look forward to discussing this more. Now, these are obviously improper redactions.
And let me stop for a minute.
I'm talking.
If they're not privileged,
quiet.
Don't yell at me. If they're not
Mr. Chairman, would you
privileged,
stop the clock? This is on your time. It's not on Mr.
If they're
Goldman.
not
Even though
privileged,
you used your improper redactions,
you'll like my answer.
to
If we
continue
review
to
them and they're not
protect
privileged,
Donald
Time belongs to the
we will
member.
be happy to release them.
We'll
after
stop the
review.
clock. We'll stop the clock. Time belongs to the member. Go ahead.
even though you used improper redactions to protect Donald Trump and other predators associated with Jeffrey Epstein, you did the exact opposite thing with the survivors and victims of this scheme. So their identification information was really the only thing required to be redacted, and it was not. And it's clear this was not a mistake. This was not by accident. This was not because you only had 30 days when you really used 75, and that doesn't even include all the hours last March that you were redacting it. But I'll tell you why it's clear it wasn't a mistake. There is an email entitled Epstein Victim List. There are 32 names. One is redacted, 31 are not. So someone looked at it and decided to redact something. And I will tell you that that is clearly intentional to intimidate these survivors and victims. Now, in an interview last week,
How will you tell me that's intentional?
in an interview last week, Deputy Attorney General Todd
You
Blanche
can't go off script.
said that any victim that wants to speak with the department has done so, hopefully. Well, thanks to the incredibly brave people sitting here behind you, we can actually ask them if that's true. Now, would the survivors and victims who are here please stand up one more time? Just by show of hands, how many of you or your loved ones actually have met with the Department of Justice and provided testimony and evidence? None. And of those of you who have not met, which is everyone, how many of you have reached out either individually or through a lawyer or representative to offer to provide testimony and evidence? All of them. And of those of you, all of you who have reached out, how many of you were denied or ignored by the Department of Justice? All of them. And despite the shameful and despicable efforts by Ms. Bondi and her department to intimidate you, how many of you are still willing to speak to the Department of Justice? All of them. Well, Ms. Bondi, it looks like you have some more witnesses to talk to.
Gentleman's time has expired.
And I yield back.
We will go to the good gentleman from North Carolina, Congressman Knott.
Thank
May
you.
I have a moment, Congressman?
Yes, ma'am.
Thank you. Here we go. Here's the photograph. This is why he wanted to repeat everything that had been said previously on Epstein. This is his state, New York. You probably don't even know who this is. Wahid Mohammed from Afghanistan.
Yes, because I'm no longer a prosecutor.
Convicted of assault. Wow, he represents New York. Wow, yet he doesn't care about the illegal aliens convicted of crimes. Assault and homicide. No longer a prosecutor, so he doesn't care about his constituents. Here we go. Arson, El Salvador, Miguel Palacios. Fermin Flores Ramales, Mexico, rape.
If you just watched that hearing and felt confused about what went on, let me clearly explain it in simple terms. What I saw was a sitting attorney general who appeared unable to answer direct questions about how documents connected to Jeffrey Epstein were handled. When Congressman Dan Goldman pressed her about specific records, the situation became tense very quickly. The issue centers on an email connected to Jeffrey Epstein and Ghislaine Maxwell. According to the discussion in the hearing, that email reportedly contained references to statements made by Donald Trump about his past relationship with Epstein. The document in question was heavily redacted before being released to the public. Goldman directly asked Attorney General Pam Bondi whether she would commit to releasing an unredacted version so the public could fully understand the context. She declined, saying the material was protected under attorney-client privilege. However, the email described was not an exchange between a lawyer and a client. It was reportedly a communication between Epstein and Maxwell. That raised serious questions about whether the privilege claim was valid. The controversy did not stop there. The Department of Justice has publicly stated that redactions were necessary to protect victims. Officials explained that they reviewed millions of files in a short period of time, and that any errors were minor and would be corrected. But Goldman pointed to a specific document titled as a victim list connected to Epstein. It reportedly contained 32 names. Only one name was blacked out, while 31 were left visible. That detail created outrage because it suggested inconsistency in how identities were protected. Critics argued that if the purpose of redactions was to shield survivors, then leaving most names exposed contradicted that explanation. Goldman then focused on whether survivors had actually been given the opportunity to work with federal authorities. During the hearing, he challenged previous public statements made by Deputy Attorney General Todd Blanche, who had said that any victim who wanted to speak with investigators had done so. According to what was described in the hearing, survivors present indicated they had reached out but had not been contacted or allowed to provide testimony. That directly contradicted earlier public messaging from the department. Another major point involved what has often been called a client list. In a previous television interview on Fox News, Bondi had stated that a list connected to Epstein was on her desk for review and that it had been directed for examination. During this recent hearing, when asked about that statement, she did not provide a clear explanation for where that list stands now or whether it exists in the form previously described. That inconsistency fueled further criticism and raised questions about whether earlier claims were accurate. Throughout the exchange, instead of directly addressing each of these concerns in detail, the discussion reportedly shifted toward other topics, including immigration enforcement. Observers saw that as an attempt to redirect attention rather than respond to the specific document questions being raised. From my perspective, the core issue here is transparency and consistency. When documents tied to a case as serious as the Epstein investigation are released with heavy redactions, the public expects clear reasoning. When survivors say they attempted to cooperate but were ignored, that demands clarification. When prior public statements appear to conflict with current explanations, that requires accountability. The hearing highlighted these gaps without resolving them. This is not just about politics. It is about trust in federal law enforcement and whether sensitive investigations are handled in a fair and transparent way. The questions raised in that room remain unanswered, and until they are addressed directly, the controversy will continue.